All right, are you all ready to go on the record?
Yes, ma'am.
All right, the court is calling 2022 CR 11724, State of Texas versus Jordan Robbins. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Amy Owen for the defense.
All right. And the other two attorneys who are here?
Yes, Judge. Brandon Wong for Alexander Reed.
All right, so everybody, please do not whisper because the court reporter cannot hear. So,
Brandon Wong for Alexander Reed.
Yes, Your Honor. Rick Foster here for Dr. Javier Rodriguez.
all right. So before we get into the reason for the other two attorneys being present,
A quiet Texas courtroom. Tension starts to build as judge prepares to hear the case of State versus Jordan Robbins. Defense and prosecution announce their presence. But they're not alone. Two more attorneys step forward, representing outside interests. The courtroom quickly becomes crowded with legal complexities. Whispering is promptly shut down. Every word must be on the record as the judge takes control. It's clear something deeper is unfolding behind this procedural start. Before we continue, make sure to subscribe to the channel for more real courtroom drama.
and did you file a motion as well, or is
I did
this?
not, Your Honor. I found out about it yesterday, but we're subject to this motion because we're the doctor, one of the doctors that is being asked to produce records for Mr. Wong's client, Ms. Reed.
All right.
And Your Honor,
So defense,
Your Honor, so as the court's aware, we have argued, sort of argued this prior to the court. And we're not on a fishing expedition to for all of her medical records, but what we are interested in and looking for are medical records that occur between January 1st of 2020.
Judge quickly shifts focus. Did you file a motion? She asks one of the surprise attorneys. He hadn't, but he's tied to the issue. Doctor, his client, is being asked to produce sensitive medical records. The courtroom becomes a legal battleground over privacy, subpoenas, and strategy. The defense clarifies this isn't a free-for-all. They're only requesting specific medical visits from January 2022. Their aim, a limited, targeted request, but one with major implications for their defense. The stakes are rising, even as the time frame narrows.
2022 up through January 31st of 2022.
all right, do y'all want to write this down, what she's asking for?
I can get it.
Okay,
Let Mr. Wong know. So there's American Health Imaging on January 6th, 2022, January 18th with Dr. Nivra Beta, January 21st with Dr. Malhorta, and January 31st with North Central Baptist Hospital ER. And then we know that the outcry in this case is February 8th and 9th. And the reason we're asking for this, Your Honor, is that the mother of the complainant.
They believe these medical records could hold exculpatory evidence. The outcry witness. The child's mother suffered a traumatic brain injury years before. Could her condition influence the case? They don't want the records handed to them, just reviewed privately by the judge.
Suffers from a frontal traumatic brain injury. We know that occurred in 2012. And those, because of, without revealing too much of our defensive strategy in this case, there's information contained within the case file of the civil discovery and within the court-ordered psychological evaluation by Dr. Richard Tice that gives us reason to believe that there could be exculpatory information contained within mother's medical records, mother's outcry witness in this case. And we believe that what is contained within those records could.
It's a delicate balance between fair trial rights and medical privacy. The courtroom listens, weighing each word. With a clear timeline and list of doctors, the defense sharpens its focus. The argument hinges on one key question. Are these records truly relevant?
Be exculpatory. We're asking for the court to do it. We're not asking for them to be turned over. We're asking if the court would do an in-camera review of these records to see if there's anything relevant to this case in terms of symptoms and diagnoses of what happened within the 30 days of outcry. And that's what we're requesting.
all right. And state,
Yes.
are you planning on calling this witness as an outcry witness or calling this witness at all?
She would be the outcry witness, Your Honor. And we had a hearing previously on this, and our position as to why we did not feel that these.
For the prosecutor pushes back. The child, not the mother. made the allegations and repeated them, according to the state. Dragging the mother's brain injury into this is speculative at best. She's only the outcry witness, they argue, not the source. The records, in their view, fall outside legal obligations. This isn't evidence, it's distraction. But the defense believes otherwise. It's not just about what was said, it's about who said it and why. The tension between legal duties and strategic gambles is now center stage.
Records were necessary was because she is just the outcry witness. She's not, the allegations themselves come from the child. The child said these allegations multiple times. And it's just very attenuated from how there could be any relevancy. It's kind of a, well, there might be something in there. And we don't know that there is. And it's the state's view that it's outside our duties to provide, which is.
An attorney for the witness enters the fray. He challenges the entire request, calling it a fishing expedition. The subpoena, defective. His client, misnamed. The motive, harassment, he claims. The mother isn't the accused, just a concerned parent who reported what her child told her. The idea that her past injury tainted the report.
Are you planning on calling this witness as an outcry witness or calling this witness at all?
She would be the outcry witness, Your Honor. And there, we had a hearing previously on this, and our position as to why we did not feel that these records were necessary was because she is just the outcry witness. She's not, the allegations themselves come from the child. The child said these allegations multiple times. And it's just very attenuated.
He says is pure speculation. The room bristles with objection. The defense may be narrowing their ask, but the resistance is now fully inflamed. Every word now feels heavier than the last.
From how there could be any relevancy. It's kind of a, well, there might be something in there. And we don't know that there is. And it's the state's view that it's outside our duties to provide, which is why they chose to subpoena independently.
Well, the court's question, this brain injury, did it occur before or after the alleged outcry?
Before.
About 10 years before.
All right.
Another voice joins in Dr. Rodriguez's attorney. He stands behind the witness and firmly says they don't want to release the records either. And as it turns out, the defense may not even be asking for his records now. The judge, listening closely, begins to form her ruling. She's heard enough to take the next step. If this is going to move forward, it must do so carefully, correctly, and above all legally. What happens next will be in her hands alone.
They actually didn't even follow the procedure. They didn't serve my client. They never served my client with the actual subpoena for any of the records they're asking for. The subpoena is incorrect because it doesn't even list her name correctly, her birthday correctly. So again, no one can even provide the information they want because again, it's just defective on its face.
But obviously, you know,
Obviously, I know about it, but and
'Cause
that's
you're
why we're
here.
here. But the reality is, Your Honor, as the state said, none of this information is remotely relevant. They're just trying to simply fish. My client, again, she's one of many outcry witnesses that have heard the child's statement. She's not the victim. She's not saying this happened to her.
but this is the person that the state is calling as an outcry.
Judge speaks. Her decision is firm. The records will be reviewed in camera by her, and her alone. No one else will see them unless she finds them relevant. The subpoena must be redone correctly, with the right name and birth date. Only specific records from January will be considered. The attorneys are told to seal them, mark them clearly, and hand deliver if possible. Judge only. It's not just about what's in the records. It's about how justice handles what may or may not be found.
Before August 24th, that would be great. If not, I can read it on August 24th, but I just like to have leisure reading before that date.
Okay.
All right, so August 24th, does anybody need anything else?
No, Your Honor.
No, Your
All
Honor.
right, and if there's not any objections from the defense, if you all want to appear by Zoom, you're more than welcome to appear by Zoom as long as I have the records to review in camera.
The judge sets the next discovery hearing for August 24th. If the records arrive sooner, she'll review them early. Any objections? None. The defense is even granted permission to appear by Zoom. As the attorneys pack up, the tension in the room lingers. A few documents, a single review, and a judge's private decision. These could change the course of a criminal case. If you found this courtroom breakdown compelling, don't forget to like, subscribe, and stay tuned for more real legal drama.